What I've done for this morning is I've just chosen a few legal issues that I think may be of interest to you. Of course, there are many others, but these are the ones that I come across most often in the work that I do. So I'm hoping that they're of relevance to you, but by all means, if you have any other questions, please feel free to interrupt as we go along, and I'll try to answer them for you. Now, this particular slide was partly covered this morning in Richard's talk, where he was looking at the different legal structures available to not-for-profits, especially within the field that you operate in. So we have incorporated associations. Now, how many of you are incorporated associations? Most, okay. Do we have any public companies limited by guarantee? One, okay. Do we have any what I call RABs, or registrable Australian bodies? Do we know what this is? So this is what Richard was mentioning this morning. He was talking about the fact that if you're an incorporated association, you're pretty much limited to the state that you're in. A cheap and quick way to be able to then operate nationally is to also register with ASIC as an RAB. So, if you did do that, you'd have what they call an ARBN, Australian Registered Business Number. So do any of you have that? Okay, good. All right. And there was also mention this morning about what happens if we are unincorporated and what's the difference. Richard did answer that correctly. If you are unincorporated, you don't have the legal protection of being inside an organisation. So as soon as anything gets wrong, you on the committee get sued in your personal names, which means all of your personal assets are at risk, your home, your bank accounts, your cars, your jewellery, everything that you own. Also, in some instances, not only are you personally liable, but your members are. And there have been cases that have gone through the courts where the members have been held responsible for something that's gone wrong. Now, D&O insurance does help a little bit in that if you get sued for, say, a breach of your duties as a director or a committee member, the insurance may step in. But the issue with being unincorporated is you can get sued for anything. So it doesn't have to be with a decision you made as a committee. It could be that someone fell over and hurt themselves at an event that you were organising, or someone is suing you for breach of contract. If you're incorporated, they sue your organisation. If you're unincorporated, they sue you. And suddenly you find yourself possibly losing everything that you've accumulated in your lifetime. So I personally have never been too keen on being unincorporated. Some organisations feel that they can live with the risk. They're small and they don't think much will go wrong. But it is worth considering as you grow, do we really want to remain personally liable ourselves? How do we get people to join our committee if we have to tell them that they could be personally liable? Is it worth even just paying the few $100s and incorporating as an association? So it's worth thinking about. So as Richard said, if you're an incorporated association, you are limited to your jurisdiction, your state or territory. If you are operating outside of that, you should have a national legal identity. That means you should be a company, and the not-for-profit version is this public company limited by guarantee, or you should be an association that's also registered as the third one, which is the registrable Australian body. How do you know if you're operating outside your state or territory? It depends on a few factors, and there is a detailed definition in the Corporations Act. I think it's section 21. But basically what you look at is, do we have employees in other states or territories? Do we own property in other states or territories? Do we enter into contracts in other states or territories? That could even mean hiring a venue for your annual conference. So as soon as you start ticking a few of those boxes, it means that you are conducting activities outside Victoria, New South Wales, whatever it is that you're incorporated, and you should do something about it. If you don't want to spend too much money, you become an RAB, you pay $400, you fill in a form, you lodge it with ASIC, and lo and behold, you are now a national body. But as Richard said, the downside to that is you've now got two legal identities. You've got to report to two different government bodies. Every time something changes, you've got to report twice. It gets confusing, and some organisations don't want to deal with that. The longer and more expensive way, but the end result is better, is to actually change into a company, which is what David was talking about. It does take longer, but the end result is better in that you actually become a company. You're no longer an association, and magically everything that your organisation owned, assets, contracts, money in the bank, your members, they all magically just go across into the company. You don't need to do any transfers. You don't need to worry about paying any tax on that. It just happens automatically as a part of this process. So worth thinking about if you are operating outside one jurisdiction. Another thing to consider as well is, even if you are an association and you are only operating in your particular state or territory, does it really suit you in terms of what it is that you're doing? So I have come across a number of associations which have said to me, Vera, legally we're fine. We operate in Victoria, we're registered in Victoria, but we are finding that no one really takes us seriously. The people on our committee don't really appreciate the importance of what they're doing. They're quite casual about it. They're not overly concerned if they're fulfilling their legal duties. We think that if we were to become a company, everyone would be more alert to their responsibilities of running a not-for-profit, and we think that it would just give us that edge of professionalism that we currently lack as an association. So the fact that you're suddenly called a director and you are caught by the Corporations Act does actually result in some committee members suddenly sitting up saying, oh my gosh, I've actually got quite serious obligations here and I should really put in a better effort, rather than just assuming it's my local soccer club where if I don't turn up half the time it's no big deal. So some organisations change not because they have to legally, but because it actually does help them operate better. Some organisations have to change because if they want to get funding from the government will say, we need you to be a company, we're not happy with you being an association. I've also found with the Corporations Act, it's much clearer in terms of what it requires of you, where you stand legally. It gives you better defences than a lot of the legislation around incorporated associations. I found personally it's easier to deal with ASIC than with the Office of Fair Trading. With ASIC, like Richard said, a lot of the stuff is online. If you lodge something late, no big deal, you pay a fine. If you lodge something late with the Office of Fair Trading and Consumer Affairs Victoria, often they'll just reject it and say start again. And I've seen organisations have to do the AGM twice because they didn't lodge their paperwork on time for the first one, have to go back and do it again. ASIC is much more knowledgeable in what it's doing. I find when I call up the Office of Fair Trading in New South Wales, sometimes I have to call them 3 times, and the answer that I get twice I figure is the right one. And further, if you are a charity, being a company is much better these days because they have synchronised the legislation, the requirements between ASIC and the ACNC, the New Charities Commission, much better. If you're an incorporated association, which I'll get to later, you still have to report to the ACNC and to the Office of Fair Trading, and again you've got duplicate reporting, and that can be quite frustrating. So there are a few other things to consider about in terms of deciding what is our best structure besides do we legally have to change. Let's move on to the exciting topic of tax. Now, again, it was briefly touched upon this morning, but as a not-for-profit in the space that you operate in, which is obviously the promotion of science, there are 3 different tax categories you can fit into. Now, do all of you know which one you're in? A, B, or C? How many of you are charities? 2? Okay. How many of you pay tax? 1, 2? All right. And the rest of you don't pay tax. And you don't pay tax because... Right.
You're assuming that we're in Tier 1.
Tier 1, 2 and 3 has got to do with whether or not you need to have your accounts audited and whether or not you've got to submit financial reports. This is completely different. This is with the tax office. So, I can't tell you how many times I have found a not-for-profit that's in the wrong category. They're paying tax when they don't have to, or they're not paying tax when they should have, or they actually could have become a charity some time ago and enjoyed the benefits of being a charity and they never bothered applying. So if you've gone through this exercise recently and you are confident you're in the right category, fantastic. If you haven't, it's probably worth having a committee spend a few minutes thinking about this because the consequences can be quite serious. Now, as we said before, to be a not-for-profit means you've got to have some magical wording in your constitution. You've got to have 2 or 3 clauses in there which the tax office requires to see. If you don't have it in there, you're not a not-for-profit. So as a basic, you need to make sure your constitution has those clauses. If you don't know what they are, email me and I'll send you the clauses. And these clauses generally, you can just copy and paste straight into your constitution. Are any of your DGRs or operating DGRs? Okay, that's a different scenario. That has different wording. But nevertheless, you've got to have these clauses in there. So that's your basis. You're all not-for-profits. Then you have to work out which of the three categories we're in. The best is generally to be a charity. You never have to pay any tax, as in income tax or capital gains tax. You don't have to lodge anything, apart from now having to lodge annual returns with the Charities Commission. And you're endorsed, which means you've got a special piece of paper, previously from the tax office, now from the Charities Commission, saying you, XYZ organisation, are a charity. And you have that framed on the front door, and everyone knows when they walk in you're a charity, and you promote that to everyone because generally speaking, the public has this element of confidence when they're dealing with charities. And a lot of consequences flow out of that. So you can get GST concessions, you can get FBT rebates, you can get refunds of franking credits, all sorts of tax consequences that you can enjoy. The next step down is you're not a charity, you're still a not-for-profit, but you don't pay tax. And to be in that particular category, there are, in your space, which is in the scientific field, and this is where I'm going to lose you, so do not get upset if you can't follow this, because it even does my head in, but you have scientific institutions, scientific associations, and scientific research funds. They've all got their own definition. In my opinion, the definitions don't help much. It's hard to distinguish one from the other, and it really does take a bit of analysis to work out which one you're in. But nevertheless, you have to slot into one of these three. And it comes down to what exactly it is that you're doing. What is your purpose? So if you can slot into one of those three, give yourself a tick. You work it out yourself. You can write to the tax office and say, tell us what we are. But most not-for-profits work it out themselves. It's called self-assessment. And please make a record of when you've done this and why you think you have entitlement to this particular category B. Keep it somewhere safe. Do it once a year, because organisations can change constitutions and activities and so on. So if the tax office ever knocks on your door and they say, we want to investigate your tax status, you show them the analysis that you've done and how you reach the conclusion that you don't have to pay tax. You show them that you've done it annually. If you've got it right, you're fine. Right? Even if you got it wrong and they want to collect tax from you, it's easier to then avoid having to pay penalties and fines and so forth if you can show you did your best effort and you thought you were income tax exempt. I had a client which was a not-for-profit, and in their annual report they actually had auditors who they'd paid a lot of money to, and the auditors said in the annual report, this particular not-for-profit is income tax exempt. One day the tax office wrote a letter to the CEO, and the letter said, we've been having a look at your activities and we've been wondering why you've never sent in a tax return. So the CEO, who didn't sleep that night, called me up the next day and he said, I'm really confused. I thought we didn't have to pay tax. Our annual report says you don't have to pay tax. Our auditors tell us we don't have to pay tax. I haven't been paying tax. I think I need to be paying tax. And so we looked at his activities and lo and behold, he was in category A. He should have been paying tax. So he then had to pay all his back tax for the last 5 years, and the tax office wanted to charge fines and interest. But we managed to write a very nice letter saying, we're sorry, we got it wrong, our professional advice was wrong, we never intended to avoid having to pay tax, can you please forgive us? And the tax office waived all the interest and the penalties. So really important to know which category you're in. With A, which is where you pay tax, you may think to yourself, well then why are we a not-for-profit if we're going to pay tax like a for-profit? You do have this, what's called the mutuality principle, which means you actually pay less tax than a for-profit. So with all of you, you all have members, you all receive membership fees, you receive money from your members for, say, issuing them a journal or attending your conferences. When you work out what your income is, you ignore all the money coming in from members. When you work out your deductions, you ignore the money you spent on your members, and what's left is taxable. So generally, you only end up paying tax on interest on your bank accounts and your dividends that you've got, sponsorship fees and so on. You ignore all the money going back and forth between you and your members, because legally you are one organisation. So the tax you pay is a lot less than a for-profit would, but you still have to be paying tax and you still have to lodge tax returns. So Where I've got their self-assessment versus endorsement, that means as a charity you get endorsed. You've actually got a letter from someone saying you are a charity. With the first two, you have to work it out yourselves, and please keep a record. Do it at least once a year. You get into the practice of reviewing your tax status to make sure you don't suddenly creep into another category and then find yourselves on the wrong side of the tax office. Now, DGR endorsement, that is different from being a charity. To be a DGR, which is a deductible gift recipient, means you can receive donations and the donor gets a tax deduction. If you are A, B or C, you can still receive donations. It's not a problem. You may need a fundraising license, but you can still receive donations. The problem is if I give you a donation of $10,000, I don't get a tax deduction for it, so I'm less likely to do it. If you are a DGR and I give you $10,000, I pay less tax myself. So it's much easier to fundraise if you have DGR endorsement. I've listed there 5 different sorts of DGRs which may be appropriate to your sorts of activities. There are about 40-something categories generally, but those 5 may be ones that you, in the promotion of science, can actually establish yourselves, assuming you meet the criteria, and you can set it up, and either your whole organisation is a DGR, or a little fund that you operate is a DGR, and so donations to that entitle the donor to a tax deduction. That is still regulated by the tax office. The ACNC doesn't get involved in that. The tax office will be reviewing your application and saying yes or no. So there's no reason why any of you can't set up a scholarship fund. I make a donation, I get a tax deduction. You use the money to provide scholarships to scholars who want to study in your particular field. You can set up an approved research institute. If you do a lot of research, again, some conditions attached to that, but that could be a DGR. If you're into health, that's another category. That's where the whole organisation is a DGR. Or if you get onto the register of environmental organisations, which may be applicable to some of you. So if you're interested in getting tax-deductible donations, it's worth having a look at these categories. A lot of this information is publicly available on the ATO website or the ACNC website. Have a look at the conditions, and it could be that if you tweak a few things, you'd be eligible and suddenly can get tax-deductible donations and your revenue increases. The last thing I wanted to say with tax was there are a lot of exemptions and concessions for not-for-profits, and it's really worth your while making sure you look through all of those and you're enjoying every single exemption you're entitled to. So I'm not just talking about income tax. It could be with a fringe benefits rebate for your employees. It could be payroll tax, which is a good one to have. It could be stamp duty on. Many of you may not have to buy any land, but insurance premiums. You can get an exemption from stamp duty insurance premiums. If you transfer a car and the stamp duty, you can get an exemption from that. GST concessions. If you're having to pay council rates because you own the building, you can get an exemption. Land tax, water rates. There are all sorts of taxes at different levels, and it's worth having a look at that to see that you're not unnecessarily paying tax if you don't have to. All right, now for the 2 of you that are charities, you'd know that you're now registered with the ACNC. You have to lodge an annual information statement. I'm sure you're tired of all of this, but if your financial year just ended on the 30th of June, you've got to lodge that by the end of the year. You still have obligations to the tax office. You generally don't need to worry about them too much. But if you do operate a DGR, you may find you've got to lodge an annual return. There are governance standards that also dictate how your board operates and what their duties are. So if you're a charity, it's a good idea to check your constitution to make sure your constitution mirrors the governance standards. And the last thing is, on the 1st of January next year, there's going to be a new statutory definition of charity. So for the first time in the history of Australia, when you ask the question, what is a charity? You don't look at case law, you look at an actual statute. It's going to be an act, the Charities Act, and that's going to list all the different categories. One of them will be science. So again, if you're thinking maybe we're eligible to be a charity, it's worth having a look at that, especially with the new legislation coming in. All right, the titillating subject of constitutions. So this was discussed a number of times this morning. It is something that I do almost daily, and so I see a lot of the issues that come up if your constitution is so old that you don't know where it is. It is good to get into the practice of having it reviewed every 2 or 3 years, and your members then don't have a heart attack when you list it on your agenda for your AGM. They just get used to the fact that you are constantly finessing your constitution because you want to tweak something, or something's not working for you, or you want to take advantage of some change in the law, and they just get used to it. So it's no longer a big deal for them. The law does change. So the Corporations Act has changed significantly. The associations legislation has changed in a lot of states significantly. If you're a charity, you've now got the ACNC legislation. If your constitution does not get changed, it's going to contradict the Act, and suddenly you're stuck because you want to do something and the Act says you can, but your constitution says you can't, or your constitution says you've got to do such and such, but that's contrary to the Act. So regardless of what you do, you're going to get caught. So it's worthwhile having a regular look to see, are we taking advantage of these changes? Even the need to no longer do audits. As Richard said, that's fantastic, but if your constitution still says you've got to do it, you've got to do it. So take advantage of these changes because they are making it easier for not-for-profits to operate. They are trying to reduce red tape. But unless your constitution keeps up to date with all of that, you miss out on all these benefits. And there are changes that you need to be careful of that you may not even be aware are happening. So, for example, with the public companies limited by guarantee, up until recently you could have a license, which is quite easy to get, and the license would say you can take limited off your name, and suddenly your whole legal name doesn't have limited. The law around that has changed. So there are a lot of companies out there that have a license that shouldn't have a license, and that requires you to change your constitution. So it's important to keep up to date. And how do you keep up to date? Obviously, a lot of people do newsletters. We do newsletters. Other firms do newsletters. If you get onto these mailing lists, it doesn't cost you a cent. You get the newsletter sent out regularly, and they alert you to different changes that are happening, and then you decide whether or not that actually affects you. Contradictions and loopholes. Big issue where Clause 3 contradicts Clause 37 because someone changed it last year and they changed one clause without realising it affected another clause, and suddenly the Constitution makes no sense. Or there are gaps. It's quite common to have gaps. So one I came across recently gave no instruction about what happens if someone leaves the board. There's just this gap in the Constitution. So then the client says, well, so what do we do now? And I have to say, well, your Constitution actually says nothing at all on it. And so then it becomes a very expensive exercise to work out, well, what does the case law say? What can you do in this situation? And the model rules that Richard was talking about earlier, really simple and easy to implement, but they have a lot of gaps. So if you're going to go down the path of choosing the easy route and using the model rules, I'm just warning you, they are so simple that they're slightly too simple and they don't cover every scenario. Finally, make sure your constitution supports your tax status. If you are a charity, your objects clause has to support the fact that you're a charity. If you're a tax-paying one, the same thing. If you're not-for-profit, the same thing. You can't have one tax status, but your constitution says you're something else. The tax office is not like that at all. They've got to actually match up. So make sure that your constitution, your objects, even your websites, even your marketing material, the journals that you send out, the leaflets, all of them say the same thing. We are a charity, or it'll say, in terms of what it reflects about what you're doing, we don't pay tax. If you have contradictory material, the tax office has a field day. I had one client where we lodged an application to convert them to a charity, and everything was fine. We were so proud of ourselves. We lodged it. The tax office came back a month later, this was before the commission existed, and said, we reviewed everything and basically we're happy with it, but we saw 2 words on your website that we don't like, and so we're rejecting it. And the 2 words were that this not-for-profit was a professional association. It looked after its professional members. If you look after your members, it's not really charitable. It could even cause you to pay tax. So we had to change the website, not appreciating the tax office would actually go online and check every aspect of the website to see, does it support what you're telling us, because you're telling us you want to be a charity. So make sure all your publicly available information lines up with what you're saying that you are. All right, the last thing I wanted to talk about was something that many of you may come across in that you organise annual conferences and you either get someone to organise it for you, so you enter into a contract with them, and I think there's a presentation about that this afternoon, or you just directly enter into a contract with a venue. So you hire out a couple of rooms in a hotel and you have to sign a contract, and these are some of the issues that I come across when looking at them. So I've just provided a checklist for you, so next time you organise a conference and you have to sign something, it's worth going through this checklist. This checklist is also good generally for any contract that you sign. So if you're not going to get legal advice, which is fine, it's worth your while just going through this checklist to make sure that any contract that you sign, to the extent that you can, doesn't leave you exposed. So any contract you sign with anyone, do a check on the other party. If it's a company, look up ASIC. If it's an association, you can do a search on them. If it's an individual, you can do bankruptcy searches. So do some due diligence with the person or the organisation you're signing up with to make sure, to the extent that you can, they're not in financial trouble, which means you're going to end up suffering as a result. Talk to people who've done business with them. Do a bit of research on their reputation. It doesn't take long. It doesn't cost much. Like an ASIC search is $20, but it'll give you some inside information about whether you really do want to do business with these people. Second thing, and this often is neglected, in the actual contract itself, I know this is silly, but have your correct legal name. Have your full legal name with the ABN, have their full legal name with the ABN or ACN, so that if something goes wrong and you need to sue them, you've actually got the right party identified in the contract. You don't want to go sue them and discover that they use their business name instead of their company name, and suddenly you've got all sorts of problems when you want to take legal action. So something as simple as that. And again, you can look up, you can go into ASIC for free and type in the company name and it'll tell you their full legal name. Or you can go onto the Australian Business Register website, type in the name, it'll give you their ABN. A lot of this stuff is for free, so you can easily do these searches. If you agreed on certain terms with them as set out in a letter or a heads of agreement, make sure all of that's in your contract. Because sometimes they'll agree to do something fantastic for you and you just assume it's reflected in the contract and it's not. And then later on you think, well, why aren't they doing what they promised us they would? Or lo and behold, it's not even in the contract. How do you then force them to do it? And you said, well, you know, they told us in our letter, but the letter may not be binding. So make sure any contract you sign reflects whatever it is that you agreed upon with them when you got to the point of actually getting a contract. GST. If you don't mention anything about GST, any fees that you pay are GST inclusive. So it's important, is it inclusive or exclusive of GST? Because it makes obviously like a 10% difference. Make sure it's signed properly. If you're dealing with a company, you need 2 signatures from the board, 2 directors or a director and a secretary. It's an association. So these are little things that will just make it easier for you if something goes wrong later on. And obviously date all your contracts. Insurance is important, especially for conferences. A lot of hotels will actually say, and I still don't understand how they think they can get away with this, they'll say to you, oh, we the Hilton will give you, 2 ballrooms and this common area where we will provide food and beverages for all of your delegates. We'll be in control of all of that. But by the way, if someone gets injured, it's your responsibility. And I think to myself, how do we have control over how you actually operate your hotel and whether or not you're following work health and safety regulations, and you're telling us that if something goes wrong because of your hotel, we have to bear the risk? And they just say, well, that's how we operate. So these are things to watch out for and try to negotiate out of. I don't see why it should be your responsibility if the hotel doesn't provide safe premises. So you can still have your own insurance, good idea, but it should be, the claim should be made on their insurance and not yours. Obviously, occupational health and safety should be their responsibility. It's their venue. You have no control over how their staff work and what sort of safety measures they have in place. So these are things that they should be taking responsibility for. Intellectual property, you're doing a conference, there's your logo or your trademark. Who's actually using it in promoting your conference? Do you have control around how they're using it, in what context? Make sure that you have some conditions around using your intellectual property. If they're putting stuff up on the website about you or your conference, make sure that you have an opportunity to control that so they're not saying something that's going to impact on you. If you have to hand over membership details, obviously privacy issues, you've got to document that. And anything that sort of, if you have a conference organizer and you create some intellectual property in organizing the conference, who's going to own it at the end of the day, you or them? If you're paying the fees, I figure you should. So make sure all of that, if there is that sort of issue, make sure it's covered. When do you pay the venue or the conference organizer? Do you pay in stages? Do you pay when a certain number of people are registered? What if you have to end the agreement halfway through and you paid too much? Can you get your money back? I've seen this happen and you lose a lot of money. If they're going to be incurring expenses on your behalf, can they just do that willy-nilly? Or if it's above a certain amount, do they have to come back to you and get your permission? When do they get reimbursed for that? If you're going to share the profits from a conference, how do you work out the revenue? And this is really important. Do you have the right to go and audit their books If they're telling you they only made $100,000 in revenue, so your cut is, I'm making this up, 50,000, you think, hang on a second, I'm sure you made more than that. Do you have the legal right to go in and check their figures to see whether or not it is in fact 100,000? Indemnities. This applies to all contracts. Please be careful with indemnities. An indemnity is where the other party says, if we suffer some sort of loss, you'll reimburse us for every cent that we've lost. Now, in some circumstances that's appropriate, in others it's not. You have to be careful how that's worded, so you suddenly don't find yourselves responsible for something you had no control over. So be careful with those. If there's a breach, what is a breach? What are your rights? Can you terminate, or do you have to sit through the whole contract and only be able to get some sort of damages back? If you have a dispute, is there a good dispute resolution clause in there so you don't suddenly rush off to court the next day? You've got to sit down, have a meeting with these people, work out what the issue is and try to deal with it before you go getting lawyers involved. When can you terminate? And then finally, have good timelines in there, good deadlines, so everyone knows what they have to do by what date. And this is where I feel like I'm a grim reaper. I have to think of every possible thing that can go wrong and then cover it in the contract. So, there have been instances where venues are burned down and it's not covered, and suddenly you think, well, what happens now? I've already given you some money, there's no venue. Where do I now organise my conference? And because it's not covered in the contract, the legal expenses go through the roof. If there was a clause in there which explained what happened, you'd have no issue. Sponsors. Now, keep in mind, if you are not a party to a contract, you can't actually sue on that contract. You've actually got to be a party to it. Your name's got to be in the contract. You've got to sign the contract. So if you've got sponsors involved and you haven't got a proper contract with them, or somehow their involvement should be linked into your contract with the venue, you just got to think about the basics of, if I need to enforce this arrangement with sponsors and they're not a party to the relevant contract, how do I enforce it? So it's just a matter of making sure that whoever is legally going to do something, they're all parties to one contract or the relevant contract. Warranties are promises. Don't make promises you can't keep, because they can sue you if you don't keep the promise. So be careful with those. Confidentiality is obvious. And this is one that often gets ignored. If there's nothing in your contract at all about a signing, now signing means you pass on a contract to a third party. So my organisation hires ABC Conference Organiser Proprietary Limited to organise our annual conference. There's nothing in our contract about either of us being able to pass on the contract to another party. ABC Conference Organiser Proprietary Limited decides halfway through that they're going to transfer this contract to XYZ Conference Organiser. And they're allowed to do that, unless the contract says they can't or they need your permission. And suddenly you find yourselves dealing with someone completely different. So a small thing, but it's worth thinking about. Now that I've all scared you to death, we've got a few minutes. Do we have any questions from any of those issues or anything else that you've been struggling with?
Insurance. The types of coverage, we have conferences, but we also have things like a soccer match at the Melbourne University and things like that. What sort of insurance should we be looking at for that?
In terms of injury to people or even damage to property, that's usually covered by a public risk. So do you want to make sure your public risk covers any event that you're involved in on any location, and that's generally easier to get. And generally other insurances you should have, obviously contents is one, that goes without saying. D&O insurance, please make sure you've got that. So that's directors and officers liability insurance. In the event that someone on your committee gets sued, you've got to have that sort of insurance, otherwise you're stuffed. If you are operating some sort of professional capacity, there's professional indemnity insurance. So if someone sues you for giving wrong advice, that may not apply to you, but that's something else to consider. And then all your usual ones, you've got theft, you've got burglary, you've got loss of rent, which you can generally get under like one policy. So what I would be doing is sitting down with a broker, and I'd be saying, these are the sorts of activities that we run. These are our operations, this is where we operate from, these are the sorts of things we get involved in. Can you please give us a list of all the different policies that you think we need to have, and then you can go through that to say, look, that's a real risk for us. Yes, we need that. Less so, no, we don't need that. And with your D&O insurance, that in itself is a whole day's conference. There's like side A, side B, side C. It's really complex as to who gets covered in what scenario. You really need to get proper advice from your broker about that, because you may find that if someone on your committee gets sued, your insurance does exist, but it doesn't do what you thought it would do. Because it gets technical about who gets covered first, the organisation or the director. What sort of legal costs are covered? Do you have to incur the legal costs before you get them reimbursed, or do you have to go through the end of the case before you get reimbursed? How does that fit in with the indemnity in your constitution? So it's really, really complex, and so if I was you, I'd be wanting to make sure that I've had a decent conversation with the broker to make sure whatever cover we have is going to protect us in the event that someone sues someone on our committee.
Vera, can I ask about sponsors?
Mm-hmm.
So we run a large annual conference. We have, say, 10 sponsors at that conference. The benefits they get are perhaps they get a speaking slot, they get 3 banners up in the Great Hall, they get a logo on the back of the book. Do I need a contract with every single one of those sponsors, or is an exchange of letters just very clearly laying out what we've agreed they get enough?
How detailed are your letters?
Where a page very clearly articulating that the Deans of Science have signed up for these benefits at this event on this date. Not very detailed.
Yeah, okay. At the end of the day, it's always a risk management issue. If you've got a sponsor who has promised you $2,000, and in the scheme of things, based on all of the expenses and all the revenue around this particular conference, $2,000 is petty cash. So if something goes wrong with that particular sponsor and you lose $2,000, you can live with it. It's no big deal. If you've got a sponsor who's giving you $20,000, and gosh, if this money doesn't come through, this is really going to affect the profitability of the conference, I would have a more detailed letter with them. I'm comfortable with you doing exchanges of letters as opposed to a formal contract, so long as someone at your end who's got authority has signed it, someone at their end who's got authority has signed it, and you either do a swap of letters and the letters are identical and the date are the same, and you end up with one signed by them and they end up with one signed by you, or even sign the same one. But just be careful with your letters that it's one thing to set at the commercial terms. You know, we agree you're going to pay us $20,000 before the conference starts, and in return for that we'll give you X, Y, Z. But it's also worth thinking about, does my letter set out, well, what happens if they don't pay? Can I charge them interest? At what point can I just call the whole thing off? What if they do something before the conference, which if I was to go ahead with them, it would really embarrass us as an organisation? So there are some things that may not necessarily be in your letter that you should think about putting in just to protect you in case something happens.
Okay, so the effect of the exchange of detailed letter or the contract is effective to protect the organisation and to ensure we get the money in the bank.
That's right. Yeah, and to give you sufficient rights that if they do something or don't do something which is critical to your whole conference, you can walk away, and you even have to think about then, if they've already paid us half the money, do we keep the money? Do we have to give the money back? So these are all the different situations or scenarios you need to sort of think about.
One more tiny one.
Yeah.
So if the sponsor, who is a $15,000 or a $20,000 sponsor who has been a sponsor for a long time and is a friend of the organisation, how do you deal with this slight awkwardness, the fact that you've never asked for a contract or an exchange of detailed letters before? Blame your lawyer. Thank you very much. That was what I wanted. Thank you.
Any other questions?
I just want to ask a little bit about privacy policy. I understand the Act's coming in start of next year, March. And as a consequence, I'm not sure everyone would necessarily have a privacy policy, but I understand that they have to. Is that true, or is it only companies? Anyway, I suppose just a bit...
The privacy legislation applies to all organisations, which includes not-for-profits, which have more than $3 million in revenue a year. So if you're $3 million and above, you need to comply with the legislation and you should have a privacy policy. If you're under $3 million a year, you don't have to, but the Privacy Commissioner is saying it would nevertheless be a good idea for you to have at least a privacy policy that's available on your website and that people can access. So most of you may not even have to comply with it, but it does, set out good principles to keep in mind when you're dealing with not only your members' details, but also details of other people who have contact with your organisation.
And I understand, so in terms of there's new rules, I don't know
Yes.
if any people get donations here and stuff, but also about data that you have, like people's details and especially changes if it's overseas,
Yes.
etc.,
Yeah.
etc.
Yeah.
Does that, again, is that only for people, organisations with over 3
Yeah, so the whole Act only applies for organisations with 3 million or more in revenue a year. If you want a summary of that, we actually just did a recent breakfast series on it. I've got a good PowerPoint and checklists. If you want to email me, I can email those to you. Yeah.
No more questions?
They're too scared to ask me.
Just with the IP for conference presentations and that, our conference organisers sort of maintains a strict control on giving us abstracts and information from the conference. Is that, should we be pushing back to them and saying, well, no, actually we need to take control of that property?
So your conference organiser is limiting your access to what the speakers are going to be.
No, well, what the speakers present is what they try to control that. In terms
Content-wise?
No, not in giving it to us as a society. So
That sounds really bizarre.
No, a really regular thing is if you were to speak today,
Yes.
it's possible that you don't want this distributed outside of this
right.
conference.
Yeah.
Or if you take photos of people, and I think people sometimes automatically stick it up on the website, but I think technically they're probably meant to ask. And just about the legalities of that, I suppose.
I don't think it should be a given that the conference organiser just automatically assumes that they will have ultimate control over, you know, what you can get access to in terms of the presentations. I think it's something that should be discussed with your interests in mind, whether you're talking with us, discussing this with the speaker directly or the conference organiser doing it on your behalf. You're paying them to act in your best interests, right? So I would have thought that you should at least try to get the material from the presentations. If someone, you know, just point blank refuses, you can't obviously force them. But
so what happens is they'll get all the presentations and they'll get the speakers to say, yeah, we agree to our presentation going on our website, but they'll put it on their own website, and we can download it from the website, but we don't actually get it.
I insist on it being on my website.
Yeah.
Last one.
Yeah, the thing, I'm trying to find my notes, but can't find it. Your example earlier about operating, registered in one state, operating in another.
Yeah.
If you hire someone who operates in the other state, so you hire the conference organiser and they run the conference interstate, are you operating interstate?
Technically, yes. When you look at the definition in the Corporations Act as to what it means to be conducting activities, it is slightly vague. Like, they list all these different activities you can be doing, and basically get the impression from reading the section that once you can tick off on at least 2 or 3 of these different activities, you are definitely operating outside of your jurisdiction. If you're doing a one-off once a year in another state, you can probably get away with it. And look, I have to be honest with you, I'm yet to hear in my 20 years of experience, you know, that the Office of Fair Trading or Consumer Affairs Victoria has come knocking on the door saying, well, we've actually been checking up on you. We've noticed that you're doing something in South Australia and Western Australia. You're no longer entitled to be in court. They just don't have the resources. They don't care. So in terms of you getting into trouble for it, highly, highly unlikely to happen. But once you start doing something on more than once a year, and you start thinking, oh gosh, you know, we've got members over there, so we really got a contract with them through your constitution. We're doing a conference a year outside of our particular state. We may even have bank accounts and others. You know, like once you start looking at 2 or 3 of these, think, gosh, we're actually doing that, we're doing that, we're doing that. That's when you start crossing the line. You should really start considering either becoming an RAB or converting to a company. But like I said, it's not as if anyone's going to come to you and say, because the Act actually says that the Director General from Consumer Affairs Victoria or Office of Fair Trading has the power to come to you and say, you're now operating outside our state. We are forcing you to become a company. I've never seen that happen. So it's a question for you, and I think once you start doing 2 or 3 of those, at least, you know, register as an RAB just to make sure. Yeah.
Okay. Thanks very much for your
Okay. Thank you.